and welcome from the Hawaii Tax Institute. We're here with Keith Schiller, who's the founder and owner of the Schiller Law Group in the San Francisco Bay Area. What errors do you typically see clients make when they're doing their gifting to their children or other family members?
From a tax planning standpoint, the most significant error is making decisions that may not be as tax efficient. As an example, the most efficient form of gifting is going to be to what's called an intentionally defective grantor trust. But clients may not be willing to undertake the various complexities involved with that kind of planning. So they're not doing planning as tax efficient as might be optimal. From the non-tax standpoint, what I worry about is our clients doing unplanned gifting. And one of the worst examples of that is joint tenancy. Also, there could be problems with not looking on a realistic basis as to the character and abilities of the children.
Can you tell us a little bit more about what you meant by joint tenancy and creating issues?
Yes, joint tenancy is a common way that people will put property in title. It automatically passes to a surviving joint tenant. And what happens oftentimes, especially between a parent and a child, is the parent wants to have the other child on title for convenience, or it may be that they want the child to receive the asset outright. Several problems will then be created. One of them being that the child could then give away the half interest, and the parent may find someone else the owner, or they could borrow against it. The child can also have creditor claims made, where the creditors could then reach that property. But what I see as an even more common problem is that the parent, typically mom, it doesn't have to just be mom, she loves all the kids equally. And she has 3 children, and she puts one of the children, maybe the one who lives closest to her, on joint tenancy, whether it's a bank account or whether it's a building. And then what happens is the property passes to that one daughter. And the other children, who are equally loved, lose out. They don't receive that as part of the overall equal division of the estate. Now, will the daughter be honorable and have that property shared among her siblings? Well, who knows? But I oftentimes see that isn't the case. So what I often mention to clients, I give them a warning, which I relate to the movie Christmas Story. It tells the story about little Ralphie who wants that Red Ryder BB gun, and everyone, including Santa Claus, warns him, don't get the gun, you're going to shoot your eye out. And sure enough, he gets the gun and he shoots his eye out. So various tax practitioners, estate planners, accountants, attorneys warn clients, don't put title in joint tenancy, but they do it anyway and shoot their estate plan in the eye.